Here you, Court of Appeals for the State of Michigan is now in session. The Honorable Michael J. Rigger, the Honorable Brock A. Schwartzel, and presiding the Honorable Chief Judge Michael Phillips. All persons have been near and drawn near, your petition shall be heard. God save the United States, the City of Michigan, the Honorable Court, please be seated.
Good morning. All right. Welcome to the Michigan Court of Appeals. This is day 2 of our Lansing case call. This is panel 4. Welcome on behalf of my colleagues, Judges Reardon and Schwartzel. I'll let the lawyers know we've read your briefs. We've had reports from our staff on all of the cases we'll be hearing today. So we're very well familiar with the facts. You don't need to belabor the facts in your argument. Just cut right to the most decisive legal issues and let us know as succinctly as possible why you think you should prevail in your appeal today. In cases involving minor children or protected persons, please know proper names, just initials. I'm not sure we really have to worry about that today. These arguments are being recorded and will be uploaded to YouTube within the next 24 hours. With that, I can call the first item today on our 10 o'clock call. It's item 12, docket number 374370, People of the State of Michigan versus Aaron Michael Painter.
Good morning, Your Honor.
Morning.
May it please the court, Zach Everett on behalf of the defendant appellant Aaron Painter here. We are here asking this court to reverse the trial court under section 5 of the MRTMA, which is the Michigan Regulation and Taxation of Marijuana Act. I think the best argument as it relates to the language concerning the processing aspect here and whether or not the conduct at issue is prohibited under the statute is the comparison between the language, excuse me, the comparison between the language in the Medical Marijuana Act and the MRTMA. I think the language in that it's almost an identical prohibitory provision that's contained in the MMA as it is under the MRTMA. And in the Medical Marijuana Act, it talks about prohibiting butane hash oil extraction in a in a public place, in a vehicle, or in the Medical Marijuana Act that says or inside or within the curtilage of a residence.
How do you define curtilage?
The area that immediately surrounds a residence. I think that the trial court resolved that probably in the best way possible. She used Black's Law Dictionary definition of it.
If the curtilage is the area immediately around the residence, how can within the curtilage not include the residence? Because I think that's a good question. Is within the curtilage, isn't it?
I think that by definition, the curtilage being the area that immediately surrounds a home necessarily excludes the home itself. I would liken it to a castle and a moat. You know, you have a moat that surrounds the castle. That's the area that immediately surrounds the castle. The castle is not contained within the moat.
Right.
Just like the residence is not contained within the curtilage. I think that there's an interior boundary to the curtilage that necessarily by the definition is the boundary of the home itself. And I think there is a host of cases that, I mean, I've never seen another case that's talking about curtilage that's not addressing a Fourth Amendment issue.
Right. Same.
So, but I have seen many cases that differentiate between inside the house and the curtilage and whether or not the same protections extend from the residence out to the curtilage. Yes, sir. So I think that just looking at the plain text of the statute is probably the best argument that we have. I think the curtilage issue was resolved properly by the trial court. I think that and I take the blame for how I argued this at the trial court. I think that the trial court judge was confused by the Korkejian case and the holding in that case. That case was not addressing anything related to the MRTMA, except for the footnote, which I think is helpful to us because it highlights the differentiation in the actual text of the different statutes. That case was talking about butane hash oil extraction. And I used that case at the trial court because I wanted to give the judge a clear picture of what that process is. And it's much more than just rolling a joint, which is what Korkejian was talking about, was the personal use exception under the Controlled Substances Act and how someone could avoid potential criminal culpability that way. But that predated the MRTMA. Once the MRTMA was passed, all of this conduct as it relates to marijuana became legal. And the fact that the law now says that you can process marijuana, as long as you're within the limits of the quantities that are prescribed in the statute, you can process marijuana in your home. Korkejian, I think, stands for the concept that processing, or excuse me, BHO is processing. And I think that's what the trial court got wrong. If we acknowledge that butane hash oil extraction of cannabis, which extraction is included in the definition of processing in the MRTMA, I think this is an inescapable conclusion here, and whether we like it or not, and I've talked to a number of colleagues about this issue. I don't like this law. I don't think that butane hash oil extraction should be legal within your home. I think that they should fix the law, and I'd like to think that we would have broad bipartisan support in that.
It shouldn't be because of this case being a perfect example of why it should be illegal.
I agree.
Because this is the sort of thing that
I agree.
that likely will happen if you're doing it inside a home.
That's an argument that can be made that I think a lot of people make. And I think we've seen lots of examples of that around the country with this particular issue, whether we like it or not. I believe that this law, as it's written, authorizes a highly dangerous activity. And I think that the legislature should fix that.
Feel compelled to agree with you.
I guess overarching this, I don't know how a consumer or a citizen would interpret this any other way. If they were familiar with the MMA and how that law is written, when you look at the identical provision in the MMMA that prohibits you from conducting BHO extraction inside your home, and then the later law of the MRTMA, which does not, I think that I think it's Peltola is the case that talked about if there's included in one law and then not in the other, we presume that it was intentional when they did that. I think the Latin, what is it, exclusio alterius, I think that applies here as well. So as it relates to my client's conduct, he thought what he was doing was legal because the law said it was legal. And not only that, but I think that there's very broad immunities that are included in the MRTMA.
So when you get to immunities, how does that relate to the manslaughter and the child abuse charges?
I think they're different. I think that there's a predicate unlawful act as it relates to the homicide charge that's necessary. That's how it's charged.
It can't be a lawful act negligently performed.
I think that it can be, but I don't think that's how it was pled by the people in this case. Their basis for levying that charge was unlawful conduct on the part of the defendant. That's how the complaint is written. The child
simply be amended below. Could it be amended? Could the prosecutor come back and amend and say, well, okay, fine, it was a lawful act negligently performed?
I think that the prosecutor could.
Would you have an argument for immunity then?
I think that we still have an argument for immunity. I think it's the same argument. Whether or not it's as strong of an argument is another matter. But I think that the broad immunities that are granted on our MRTMA that talk about that the person will be subject to no penalty under the law, I think should override here. I think that should be
I
controlled.
mean, is that a get out of free jail card for everything that involves this extraction process?
I don't think it is. I don't think it is. I think that if the prosecutor can point to other actions on the part of the defendant that could give rise level to criminal culpability, I think that they could charge it that way. But the basis for these charges is that the fact that my client was conducting this processing within his home, that is the basis for these charges. Do I think that they might be able to bring different charges or the same charges differently? Maybe. I don't think they can bring them the way they brought them though.
Any other questions for counsel? No. Okay. Anything else?
No, Your Honor. Thank you.
Thank you. Counsel, you're not endorsed for argument. I'll ask my colleagues if they might have any questions for you. I don't. Do you?
Nope.
Okay. Thank you very much for appearing. Thank you for coming today. Thank you for your arguments, counsel, and the case is submitted. Okay. That brings us to item 13, docket number 364-447, People of the State of Michigan versus Jason David Sadowski.
Good morning, Your Honors.
All right.
May it please the court. My name is Garrett Burton. I'm from the State Appellate Defender. I'm appearing on behalf of Mr. Sadowski. Your Honors, I just want to touch on the video and then Mr. Sadowski's motion to replace his counsel, but I'm happy to answer any other questions that you have. And before I begin, I just wanted to make sure that you all had an opportunity to see the video.
I did, and one question I had, it appears from the transcript that the entire video that we have was played for the jury. It wasn't just because there's a part where your defendant or your client is sleeping or lying on a bed. The other guy comes in and acts in a very odd way. Your client gets up, there's a fight, pretty one-sided. You know, the other guy loses consciousness for a bit, for a few seconds, comes to, sits up, and then a security guard comes in and basically says, "What's going on? You okay?" And the other guy says, "Yeah, I'm fine." And, you know, that was the gist I got out of it. Was that that description of what I just gave, was that all played for the jury?
You know, I don't actually know what was and wasn't played for the jury.
We can ask the prosecutor. The prosecutor might know. It seems from the questions being asked and the testimony being given that it was.
That was my understanding as well.
Okay.
That was my assumption, but I don't know if it was cut off.
Okay.
Like as soon as the fight ended.
I think we have the same understanding that based on the context, it appears the entire video was played.
Yeah, no one has told me that isn't what happened.
Okay, thanks. I appreciate that.
No problem. So with that in mind, Your Honors, specific acts evidence is admissible only in 3 circumstances. The first is under MRE 404B. And this court in the interlocutory appeal said that video was not admissible under 404B. And even then it was more prejudicial than probative. The second 2 circumstances are under 405A and 405B, right? And so under 405A, that specific acts evidence is admissible so long as it is elicited on cross-examination. And that's not what happened here. Mr. Sadowski was not cross-examined on this video, and he didn't have an opportunity to explain what happened. And the prosecutor in the prosecutor's brief doesn't even try to argue that this was admissible under 405A. So that leaves 405B. And under that subrule, evidence is admissible if it goes to an essential element or claim of a defense. People v. Harris, the Michigan Supreme Court opinion, it's black letter law. It says that aggression is not an essential element of a self-defense claim. And so for that reason, this video was not admissible under 405B. So the prosecutor in the prosecutor's briefing sort of twists Harris. And what she does is she conflates aggression with the reasonable apprehension of harm. And Harris makes clear that those are 2 different ideas. So aggression is circumstantial evidence of who struck first, whereas the reasonable apprehension of harm is an essential element of a self-defense defense. And that speaks to whether or not someone in a defendant's position would reasonably fear the person who's confronting them. They're separate ideas. And 405B does, in fact, allow Mr. Sadowski to present specific acts evidence of the reasonable apprehension of harm. It doesn't give him the opportunity to present specific acts evidence of aggression. And so he didn't do that all throughout his trial. He only presented specific acts evidence that spoke to the reasonable apprehension of harm. So no door was opened, like the prosecutor seems to contend. And as a result, the evidence, it wasn't admissible.
What was the prejudice?
And the prejudice, Your Honor, was a video that this court, again, has already held under MRE 403 is more prejudicial than probative, of my client, I think, pummeling that man. Like you said, the fight was one-sided, but I think that's putting it charitably.
But when you put that, I don't disagree. The video was fairly one-sided. Again, the guy who got beat up acted in a very odd way right before then. Be that as it may. Your client also testified at length and in great detail about his prowess as a martial arts expert. And made it very clear that he was very skilled at fighting. And then you have the evidence of the victim having to use a cane, you know, being an older gentleman. I mean, the jury already had evidence before it of kind of an extreme difference in skill level. And then you look at the body of the victim. Lots of damage and injuries to the body, let alone death. So how is that not overweigh any prejudice of the video?
Sure, Your Honor. So I want to talk about the standard of review, and then I'll address your question more directly. So first, again, this is a preserved objection. The prosecutor has to prove beyond a reasonable doubt that this was not admissible.
Was there an argument under 405?
Yeah. The trial attorney tried his best to argue under 405 and he didn't, and that's why I raised it in the alternative as ineffective assistance of counsel to the extent that he didn't appropriately make the right argument. And that's why, even if you don't think that it was properly objected to, ineffective assistance.
So we assuming I'm not going to speak for my colleagues, but assuming I don't think it was properly preserved.
Okay.
Then you look at it under plain error, which has a prejudice component, or ineffective assistance, which has a prejudice component. They're different, but they're not totally dissimilar. So how do you show prejudice?
Sure. All I need to show then is a reasonable probability of a different outcome. And Mr. Sadowski testified he only punched the decedent 4 times. And I think what this video shows is someone who maybe can't restrain themselves. And I don't know about you, but I think the jury, after viewing this video, is not going to credit Mr. Sadowski's testimony that he only punched him 4 times after seeing him repeatedly hit this other man. And so I think it calls into question the entirety of Mr. Sadowski's explanation of what happened. And it makes him look not like someone who is a martial arts expert who can control himself, who understands the outer limits of his strength and things like that, but as a bully and someone who is gonna repeatedly attack someone. Your Honors, do you want me to talk about the ineffective assistance of counsel piece with regard to the failure to advise Mr. Sadowski about the risks associated with certain testimony?
It's your argument.
Okay. Well, I would just say, even if you disagree with me that video was admissible, the trial attorney testified that Mr. Sadowski was the one who was talking about or sort of directing him with regard to what evidence would be presented. But nobody said that Mr. Sadowski knew of those risks that are associated with opening the door to character evidence. And so even if you think that the video was admissible, either because Mr. Sadowski opened the door or something, trial counsel was still ineffective for not properly advising him about the risks associated with that. And there's been no argument otherwise. Lastly, Your Honor, Mr. Sadowski should have got a new attorney. So as a threshold matter, both the trial court and the prosecutor cite the wrong standard for when an individual is entitled to a new attorney. So the trial court cited Strickland, and then the prosecutor cited the standard that's invoked when an individual has retained counsel. When an individual like Mr. Sadowski has appointed counsel, an individual is entitled to new counsel when there is a fundamental difference of opinion about what witnesses to call our trial strategy. And that's what we have here. They did not agree on what to do. The relationship had broken down. They were yelling at each other. They were cursing at each other. Nobody trusted one another. It was that trial attorney's first ever murder trial. And this was brought up multiple times over the course of several years. And I think at the end of the day, this is not a situation where someone got 4, 5, 6 attorneys. This was one attorney who didn't know what he was doing. He admitted as such at the Ginther hearing. And for that reason, he should have been replaced with someone who was. So with that, I'll reserve my time until rebuttal.
Questions at this point? Okay, thank you. You have time for rebuttal.
Good morning, Your Honors. Monica Wilson, Assistant Attorney General on behalf of the people. Judge Schwartzel, as to your question about the video, I believe, like Mr. Burton, that was what was admitted. When we received a letter from the court about 10 days ago asking for a copy of the video, we were CC'd on it. I did reach out to Alger County, so I have, or my office has the video that was admitted.
We have the video.
Okay, I think I have whatever was admitted.
Okay.
But I can check and make sure they're the same, but top of my head, I think they are, but
It certainly seems consistent with the testimony that was being given while the video was being played and everything. I just wanted to make sure that you all didn't have information that would be different than that.
I don't have any information that's different, but I cannot say 100% certain, just in all candor to the court, that was the exact video.
All candor's better than less candor.
Yep.
Mhm.
As it relates to the video, Your Honors, as it relates to the character evidence, Mr. Sadowski, during the defense's case, put in both kinds of evidence, the reputation and opinion testimony, as well as the specific acts of conduct, which were then made a part of his essential element of his claim or defense, thereby allowing the specific acts of conduct. Because if it wasn't an essential element of his claim or defense, he would not have been able to put in the specific acts of conduct, which in this case was the testimony about the deceased pushing, I believe it was Gail Verbunker down the stairs or something along those lines. So under the court rule about, or the evidence rule about in homicide cases involving self-defense, that the prosecution is allowed to, in their rebuttal, once the defendant puts in this kind of character evidence, to rebut that.
If it was error, was there any prejudice
No.
either under plain error or ineffective?
Absolutely not.
Okay,
And
why?
so when you look at the testimony in this case, one of Mr. Burton's arguments was, well, this video would cause the jury to question Mr. Sadowski's credibility. There was a lot of evidence that would cause a jury to doubt Mr. Sadowski's credibility, starting with the statement that he gave Chief Nelson almost immediately after he was arrested. At that point, he never said it was self-defense. He actually disclaimed that he was there. He lied about any involvement in this. And I believe Chief Nelson was asking him repeatedly, was it self-defense? And his answer was never, it was self-defense. His answer was, I wasn't there. I had nothing to do with this. I was gone all day. So, and you also look at the medical examiner's testimony, the extent and severity of Mr. Mazzader's injuries that led to his death. He had broken teeth, he had facial fractures, and I think the most telling injury was the broken hyoid bone, where the doctor testified as to what it takes to cause that fracture, to break the bone, and how protected of an area that is. So
Then the defendant did testify to a great extent about his martial arts skills and experience.
Yes.
Fair?
Very fair. And I believe it came up even at the Ginther hearing, where I believe Mr. Sadowski, either he said it or trial counsel said it, and he didn't object to it. Sadowski wrote the opening statement that just talked about what a great fighter he was. And Your Honor, you used the word I was going to use about his fighting prowess, even in his own testimony. Pages of that transcript is devoted to Sadowski telling the jury, basically, he was the greatest fighter in the world. And then you have the decedent, who was a believe an older gentleman. He had a busted hip that had gotten infected. He has a cane, so he's got a bone infection in a hip and elderly and all these things. So, and even the medical examiner also testified, in addition to the severe fractures around his head and his neck, he also had defensive wounds on his hands. So I don't see whether it's plain error or whether it's preserved error, or the ineffective prejudice analysis. There's no prejudice here.
So if the defendant opened the door to the character evidence in the
Correct.
form of the video, why shouldn't we consider that ineffective assistance to open that door?
And I believe that that was the topic of most of the Ginther hearing, where they talked about how trial counsel had his strategies. And unfortunately, and I believe even trial counsel said this, he didn't have a lot to work with here, largely because of Sadowski's initial statement to Chief Nelson. And this is one of those cases where I believe we say it a lot as prosecutors, tough cases require tough decisions. And trial counsel explained how he had to somehow try to convince the jury, and this is his words, not mine, that the decedent wasn't just some quote cranky old guy, that somehow there was that
Physically.
he was
violent.
physically capable of fighting. And I think trial counsel just said Sadowski wanted to use the character evidence, and in any event, he had to find some way to try and convince the jury that the decedent had the capability of fighting to the point where Sadowski would be justified in using self-defense. And the mere fact that it
If
was
the
not
victim
successful.
wasn't an aggressor, at least at the beginning, there is zero self-defense in practical terms.
Correct, especially in light of the statement to Chief Nelson, where he just lied and said I wasn't there. And only after any other option didn't work that he claimed self-defense. So this is one of those cases where trial counsel just fortunately had to work with what he had to work with. And I think self-defense was his only argument. And it's a tough call. It's a risk, but sometimes you got to take it. And honestly, I don't see any other defense that was available here because there was no alibi. There was no, it wasn't me. Trial counsel had even talked about it at the Ginther hearing, if I recall, trying to maybe argue this with a manslaughter case. But then he said, even noted that the extent and severity of the deceased's injuries, quote, took it out of the realm of manslaughter. So this is just a tough case, and there just wasn't a lot for trial counsel to work with. In Your Honor, too, as I was arguing to Judge Schwartzel, even if it's ineffective, there's still the prejudice prong, which the extent and severity of the injuries and Sadowski's fighting skills and lack of credibility would, I believe, excuse me, belie any claim that he was prejudiced by this video. And then I will also touch on the issues about counsel. 2 years before trial is when Sadowski filed his first motion to remove counsel. And, there were some discussions about he wasn't doing enough, he wasn't responsive enough. And the trial court made the statement that we've still got a while before trial. So there's time to work on this. Almost 2 years later is when he only brings this up again.
About a month before.
About a month before trial, which was about 2 years after the initial hearing to remove counsel. He didn't make any motions in those 2 years and didn't write any letters to the court. Sadowski also at the Ginther hearing, I believe, referred to himself as a legal expert. So he would know he could write a letter to the court. He could complain to the court about counsel. And so the fact that he waited until a month before trial to bring this back up, I think the trial court findings that this was a delay tactic and he was negligent in asserting this right, those were not clearly erroneous decisions. And in some of the cases that were cited in the reply brief regarding whether or not you have to show prejudice, I looked even at the first case last night, which I believe was the James case. In that case, the trial court made the finding it wasn't negligent, it wasn't delay, it wasn't a tactic to get a new trial. Trial court in that case denied the motion just because of timeliness and docket concerns. So I think that case is factually dissimilar here, where Sadowski knew how to complain to the court about his attorney. He waited until the eve of trial when the issue, or what he says was the issue, had been an issue in his version for at least 2 years. So there was no reason to wait 23 months approximately to re-raise the issue unless he was trying to delay the trial. And then there's the issue of the other attorney in the case, which I believe kind of was alluded to as who he wanted to represent him. he called as a witness at trial. So Mr. Ruiz couldn't have been trial counsel and a character witness. So
Sounds like Ruiz was still involved somehow.
he was allowed to be involved.
helping.
But I think the way
helper.
they worked it out was Ruiz was allowed to, I don't want to say second chair, but kind of be behind the scenes. But if he was going to testify, he just couldn't be in the courtroom. Like the jury couldn't know he was working
Very
on.
odd situation.
Very odd situation. And that came up at the earlier hearing, and Sadowski didn't object to it. And both trial counsel seemed to be okay with proceeding in that fashion. So,
Okay, anything else?
no,
All right,
thank you.
thank you very much. Mr. Burton?
Yes, Your Honor.
So I want to make a couple of points about what the prosecutor just said. The first is that putting forth the evidence doesn't automatically make it an essential part of a claim or defense. There is lots of evidence that is presented by either side that is not essential, completely necessary to a claim or defense. You're allowed to present evidence that is not in and of itself essential. And that's what happened when the aggression testimony came in. To the prejudice point, I want to say three quick things. The first is that the prosecutor would not have risked, violating this court's interlocutory order if the prosecutor didn't think that this video was absolutely necessary. And I think that speaks to the power of that video, and two, the prejudice that it caused Mr. Sadowski. What's more is that I think the injuries that Mr. Mosader suffered are sort of misleading in the sense that he was sort of frail. And so in the minds of the jury before seeing this video, it was very possible that just 4 punches could have caused the damage that they did. And the last thing is that
In light of what the prosecutor or the appellate just argued in terms of Mr. Sadowski changing his story so much, wouldn't that affect his credibility?
Sure. I mean, I'm not arguing, Your Honor, that he came in as the most credible person either in the world. He did change between when he was in.
You're saying the 4-punch statement was turning the tide against him.
The video in light of the 4-punch statement. So,
Okay.
Yeah. And so, it sort of became, I think, almost unbelievable that he only landed 4 punches when we see this video of this man.
He may have been unbelievable before that.
He may have been, but we only need to show a reasonable probability, Your Honor. The last thing I'll say is that a different outcome is also a manslaughter verdict. And so maybe it was an unreasonable amount of force that he used, but in the throes of a fight,
It's got to be hard. There's a tension between saying, well, in the throes of a fight, when just a few moments ago, you were arguing about how frail this victim was. And I think the frailty is the more accurate way to put it. And I think that's, this gets also to your argument about, well, was defense counsel ineffective for not warning Mr. Sadowski? That was Mr. Sadowski's only chance, is to show somehow that this victim, who was very frail, was still somehow physically aggressive. And so if you're going to say, well, he was physically aggressive, even though he was frail, that does go against the other ineffective assistance of counsel argument you're making.
Well, I would say this, Your Honor, is that it sort of kind of speaks to the argument I was just making, that manslaughter threads that needle. Like, he may have been frail, but that does not mean that he was completely incapable of starting a fight and creating the emotional excitement necessary to mitigate murder to manslaughter. With regard to the ineffective assistance of counsel piece, the prosecutor is misrepresenting what happened at the Ginther hearing. The trial attorney, he did acknowledge that the case was difficult for the reasons that the prosecutor said, but then he threw up his hands and he said, I'm not making any decisions. I'll let Mr. Sadowski make them. And Mr. Sadowski was making those decisions without the benefit of understanding the implications of the character evidence. And so there wasn't the adequate advice necessary to render that performance reasonable. With regard to the timing of the motion, so the interlocutory appeal was pending in between those 2 years. It's not like very much was going on while this court was deciding what had happened. And in addition to that, the case law is very clear that these motions are timely even on the day of trial. So People v. Williams is a case that says you can get a new attorney even if you make this this motion on the day the jury is coming to be sworn in.
But he waited 2 years to make that motion, correct?
Yes.
A long time, and he was piling a lot of tasks on the attorney, wasn't he?
I don't think so, Your
If
Honor.
he was that unsatisfied, why didn't he raise it earlier?
Well, again, the interlocutory appeal kind of put things on ice. But I think it stands to reason that being told no so forcefully by the trial court makes it seem like the motion is going to be fruitless moving forward.
Scared him off?
Yeah.
Huh.
The last thing I'll say, Your Honor, is that the prosecutor talked about Mr. Ruiz and how it created this unorthodox situation, but it was an unorthodox situation in large part because the trial prosecutor was playing a game and putting him on the witness list. And so the idea that he was a res geste witness is, I think, completely belied by the record. There's no evidence that he was there or someone who could see what was happening. And to fault Mr. Sadowski for sort of being caught up in the game, I don't think is appropriate.
No, this is rebuttal and we haven't talked about it yet. It wasn't part of your primary argument, but I will invite you to say a couple brief words about the scoring of the offense variables if you wish to do that. If not, that's fine too.
Sure, Your Honor. So the prosecutor concedes that OV6 was improperly scored. And I think my reply brief sums up the argument that I'd like to make, which is that the conduct that was used to score OV12, this idea that he had explicit pictures on his phone, was also the same conduct that was used to score OV13.
I don't know that it matters for purposes of this appeal, so I don't need I'm not asking for any additional research or anything,
Yeah.
but Mr. Sadowski wasn't being charged in this case with any child sexually abusive material on a phone. There seemed to be some indication that there might be other charges.
Mhm.
Do you know standing here whether he's been charged and convicted of those other acts?
I think they were ultimately dropped.
I think, I think he might have been initially, but
He wasn't. No, you're right, Judge Goodwill. He was initially, but I think after the sentence was handed down, they dropped them. That's my understanding about what happened.
Okay. All right.
Yeah.
Thank you.
Thank you very much. I think, is that it? All right.
Yes.
Very good. Thank you both for appearing. We appreciate your arguments and the case is submitted. All right, that brings us to item 14, docket number 370516, People of the State of Michigan versus Joseph Paul Marison.
Good morning, and may it please the court, Jonathan Simon on behalf of Mr. Marison. This case also involves substitution of counsel. Mr. Marison requested substitution of counsel, I think, early in the proceedings, before even a trial date was set. And the court says, well, no, I have a policy. I don't replace public defenders. And the assigned attorney was not even present at the time. I think that the chief or maybe deputy chief public defender was present. And he says, no, we're not going to withdraw. We're not going to substitute another attorney in our office. He either has to go with the one we've given him, or else he has to hire his own, or I guess appear pro per. And the court did not even give Mr. Marison any opportunity to explain his reasons. It just stated its policy. The defender stated its policy, and the matter ended up being tried by the attorney he wished to have replaced.
Why did he want to have him replaced?
Well, that's a good question, and we don't really know because he wasn't given that opportunity. In the people's reply, they say, well, we don't know the reasons, we haven't, I'm attempting to go through the Atkins factors, but without any opportunity. And I think certainly the court had a duty to inquire. The court had a duty to attempt to ascertain the reason for this request.
Did he submit anything in writing to the court?
No, it was an oral motion, and it was made, I think, early in the proceedings, and it was
Early in
flatly,
the proceedings?
sir?
I'm sorry, you said early in the proceedings?
somewhat early, certainly before there was a trial date scheduled. And so it would not, there was no apparent attempt to delay the proceedings, no attempt to interfere or with the court's scheduling. And it's interesting that there's a lot of reasons why, which became apparent during trial, that perhaps explained Mr. Marison's reluctance to.
He did say that he wanted a new attorney and you can't talk me out of it. That's the only reason he gave, was from my reading.
Well, that's the only opportunity he had. The judge says, no, it's my policy. I'm not going to replace the public defender's office. The deputy or the chief public defender says, no, we're not going to replace Mr. Silverthorne with another attorney. And I don't know how many attorneys are in the public defender's office, but I'm certain that there was somebody else who could have taken over the case.
Is there anything in the record? Because typically we see these, it's usually a motion made by defense counsel saying that there's been a breakdown in the relationship. My client is insisting on having a different attorney. Your Honor, here's the reasons why. Please make a ruling. Is there anything in the record to suggest that his defense counsel somehow refused to bring a motion or in any way inhibited his client from bringing the reasons why he wanted a new attorney to the attention of the trial court?
Well, the short answer, I guess, is no. There was no motion. There was no, as I
Wouldn't it
said,
maybe be ineffective assistance of counsel if defense counsel refused to make a motion requested and demanded by his client with regard to breakdown? I mean, that's typically how you would see it come up on appeal, but we don't have anything.
yeah, well, what we do have is a number of issues that came up during the course of the trial, which I guess kind of explain Mr. Marison's inability to have a meaningful attorney-client relationship with Mr. Silverthorne. Mr. Silverthorne attempted to bring out a more than 10-year-old larceny in order to show somehow that now Mr. Marison is sober when he wasn't previously. He attempted to bring up a failed polygraph to just some attempt to show that the statement was coerced or involuntary. This is the same attorney who in closing conceded or at least brought out his opinion that in the number of cases he's tried involving criminal sexual conduct, delayed disclosure is common. So, which I think conceded some of the doubt that a jury might have had. There's just a lot of reasons why this case, I think, was not appropriately tried and perhaps may have been better handled by a different attorney who might have had a working relationship with Mr. Marison. As far as the final argument is concerned, the Cardays issue, that has been settled now by the Michigan Supreme Court. So I think that it is no longer a question in this state that lifetime electronic monitoring is not considered cruel and or unusual punishment. And the people have provided a copy of that opinion. I may be wrong, but I think that my brief was filed before Cardays and the people filed a brief afterwards. So I think it was pending at the time. Or perhaps I just had not been realized that it had been settled at that time. But we asked the court just to concentrate its efforts on the first three arguments.
Any other questions for Mr. Simon? No. You have time for rebuttal.
Thank you.
Good morning, Your Honors. Andrew Burge, Assistant Prosecuting Attorney for Ingham County. I want to take on the issue first of the pro se oral motion, which has been interpreted on appeal as a motion or request for substitute counsel. On its face, it was to fire his attorney, which the judge correctly doesn't have authority to do. But liberally construing it as a motion for a substitution of counsel, this court's precedent is that there must be a showing of good cause. And so that's the movement's burden.
What the argument that he didn't have the opportunity to show good cause?
Well, he was able to speak at the hearing and there was no one shutting him down from speaking. And he certainly felt free to speak on his own. And he made clear he really didn't want to engage in a searching inquiry of his reasoning.
That was pretty clear, I think, when he said, you're not going to talk me out of it.
Correct. And also, I think your honors have already brought up the issue of, counsel have an obligation as officers of the court and, certainly in terms of the Constitution for providing effective assistance. And it's clear from the colloquy that the defense office, the public defender's office, was aware of Mr. Marison's concerns. There had been some communications, and I think the interest in having a record for Court of Appeals is certainly appropriate, but at the time, I think counsel is well aware that they have to be careful to not put too much in the record about what issues there may or may not be between a counsel and their client, because they could prejudice the case. The prosecution gets to find out maybe what some of their strategies are. And so it's about as good a record as you're going to get for when someone has a burden of coming forward, but then chooses not to when you have lawyers who have obligations to their client, but isn't feeling that those rise to the level where they need to withdraw. And I've seen cases, and the court has seen cases where defense counsel in good conscience feels communications have broken down. Their client is entitled to a lawyer that they can communicate well with. And so they move to withdraw, and the court undertakes the searching inquiry to make sure that motion is appropriate and that substitution counsel is appropriate. And we just don't have that record here. And I know appellate counsel has pointed to a number of things down the road that might, to his mind, support the idea that maybe counsel wasn't effective. In terms of the specific claims that were raised, I've responded to those in my brief. To the extent there were other arguments that were not raised, the court, again, doesn't have a record to decide about what the polygraph or whether research could have been suppressed. There was no Ginther motion. So again, no record for the court to decide on those issues either. So while I don't have a specific case for you to say that the court doesn't have an obligation to engage in a search inquiry, it's clear that the court does that only upon at least a facially allegation or assertion that there's been a breakdown or that there's a problem in terms of such a disagreement of strategy that the counsel should be replaced. And that makes sense to have a searching inquiry at that point, because now the court has been faced with something that facially looks like a legitimate reason to replace counsel, but that doing that has administrative costs on the court. It delays cases, and maybe it's going to end up prejudicing the client. And so that's when you have the searching inquiry. There's no obligation for a court to sort of come up with the grounds for replacing a lawyer when, and particularly when the defendant doesn't want to have that kind of colloquy. Beyond that, there are some ineffective assistance claims. I want to make sure that the court is clear, since colleague has been accused of potentially prosecutor misconduct. I want to make sure I defend that. The Lori here, it happens in court. Witnesses just volunteer stuff. They spit out stuff. It's not what you sought. And that's what happened here. Prosecutor asked an appropriate yes or no question, and the witness kind of went on. I think I covered that in the brief. There's no misconduct there, and also no prejudice in terms of what that witness spit out about vouching for her daughter. In terms of the lifetime electronic monitoring, I anticipate at some point the Supreme Court will take that issue up. But as I pointed out in my brief right now for Halleck, that decision continues to bind its punishment to have that electronic monitoring, but it's not an unreasonable search. It's not crude unusual. Mr. Marison's circumstances, individualized circumstances, are even more egregious than in Halleck, when this court upheld the lifetime electronic monitoring as both not cruel, unusual, and not an unreasonable search. So absent any questions, sit down.
Questions for counsel?
Nothing.
No. Thank you.
Briefly, with respect to the misconduct argument, certainly the question was basically asking her, the witness, whether the complainant would make things up. And although the answer was no, she does not lie, I suppose it's technically unresponsible, because it wasn't a question, does she lie? It was a question of, does she make things up? But I don't know how the prosecutor could think that there would be any different response. I mean, even though she said something that maybe he might not have technically asked, it certainly was within the realm of possibility and probably certainty that that would come up. And that for that reason, we believe that the question was improper and that it prejudiced Mr. Marison. And as an added reason,
I think you got to be a little bit more careful about that because the question wasn't, does she make things up? It's, did you ask your daughter to make all this up to get the defendant in trouble? That is a yes or no question. It's
Well-
not, does your daughter make things up? I think every parent would have to say yes at some point. The child has, but did you ask your child to make something up? That's a very different question.
yeah, I agree. And I did, I think, correctly stated in my brief. I may have
And
misstated
that's
it
fine.
here in oral argument, but on paper, I think I did capture the exact quotation. And for that reason, we believe that it was improper. It could only lead to inadmissible testimony, and we believe that it shouldn't have happened.
Okay, any other questions? No, thank you. All right, appreciate your arguments. The case is submitted. Mr. Simon, you can stay right where you are. Sure. Oh, well, apologize.
You woke us up anyway.
Yeah. Don't need another coffee. Item 15, docket number 371603, people of the state of Michigan versus Jennifer Faye Kincaid. Mr. Simon.
Good morning, Your Honors. And again, Jonathan Simon on this case involving Miss Kincaid. This is a very sad case. Miss Kincaid was the mother of two infant twins, and the boy died as a result of exposure to fentanyl, which was within the house. There was evidence that she and the baby's father were both drug addicts. CPS had been involved because the babies were born drug addicted. There was certainly drugs in the house. But my concern is that right after learning that her son had died, she was taken into a police car parked outside of the house.
Wasn't she seated in the front seat of the police car?
You know, I'm not sure because the people say that the door was unlocked, and I do know anecdotally that you cannot get out of the back seat of a police car from the inside. Not from personal experience, but so I've been told.
Good clarification there. I do think there's evidence that it was in the front passenger.
Okay.
But you have seen people in the backseat of a police car.
Yes.
Heard about such
I've seen a
things.
lot of video of clients in the backseat of police cars. And I know that they are admitted by the officer and they are removed by the officer. But if this was in the front seat, still, it is a coercive situation. She has just experienced the death of a child, an infant child. She's hasn't had sleep. She's under a lot of stress. There was no Miranda warnings. And the people say, well, she's not in custody. But and so Miranda's not required, but in this coercive atmosphere, I believe that there should have been some kind of a warning.
And I take your point that this was a very upsetting event, but it wasn't, I guess I want to make clear, it wasn't immediately after. It was like, I think they found the child dead around 10 a.m.-ish in the morning. And this conversation occurred around 6 p.m. And there had been conversations among the police officers and the other people in the house kind of all throughout the day. Is that a fair? It's the same day, but there was about 7 or 8 hours difference. Is that? I want to understand when you say immediately thereafter, how immediate are you talking about?
Well, it's certainly during the time of the excitement. And if you look at cases, I think that talk about excited utterance, they say it doesn't have to happen right away. It has to happen during the period of time where the excitement exists. And certainly using that rule as an analogy, I think that she was still under the stress, even though it was hours later.
Did she have the wherewithal to be hiding drugs before the police arrived, after they discovered the dead child?
Well, there certainly, she wasn't the only person in the house.
Did she admit it?
Yes.
Did she admit that they were hiding drugs before, after they found the dead child before the police got there. They wanted to get rid of drugs because they knew they had illegal stuff there. Is that, and she said that, fair?
Yes,
During the second interview, she said that.
correct.
Okay.
Albeit without Miranda warnings.
No, the second one she did,
Yes.
or I don't know. The second one is not at issue.
No.
I'm talking about the one that was sometime, it wasn't the same day, it was after.
I believe so. We're concerned with the statement in the police car hours after, on the same day of the death. And we believe for the reasons stated in argument one that this was not fair. And this is preserved constitutional question, and we believe that denial of the motion to suppress was an abuse of discretion. We've also pointed to the prosecutor's argument that she's a liar, that she's, she had 787 days to make this up. I think that was improper and that counsel should have objected. As far as the length of the sentence, I don't think I've seen a single case where the court has overturned a within guidelines sentence under Posey for proportionality. But under the circumstances, we think the court should perhaps consider
There's one
doing
out
so
there.
in this time.
I'm aware of. I didn't write it, but there's one out there.
Oh, is there?
Yeah, keep looking.
Okay, will do. Thank you. Well, I don't know, was that before or after this
Might have
brief
to
was
call this
filed?
chambers. when we're done.
Oh, no, don't be, I'm not doing your legal research for you, but
No,
I am
I'll-
aware of one.
I will ask Westlaw to pull all the Posey cases. Thank you.
Good morning, Your Honors. May it please the court. Jared Schultz, Assistant Attorney General on behalf of the people. Just briefly in response to the sentencing argument that opposing counsel brought up, this is not an ordinary manslaughter case. The jury convicted the defendant mother of causing the death of her own one-year-old son. If that weren't enough, she also, on top, after finding out that her son died of a fentanyl overdose, she continued to use. She had another child that was also born opiate addicted. So I certainly think that this was a proportional sentence within guidelines. As for the statements, I think the statements were properly admitted, and I think there's three reasons. First, there was no Miranda violation. As we've pointed out in our brief, that Ms. Kincaid was not in custody here. She was in the front seat of the car. She had just seen the father of the child also be interviewed in the police car, and he was not arrested after that interview. It was a short 30-minute interview. The whole point of the interview, the officer said multiple times, was just to figure out what happened here, why the baby ended up dead. And he said multiple times on the stand that he thought this possibly could have been a co-sleeping case where the child was slept on. So all this was him trying to figure out what happened. It was not an interrogation. It was not custodial. And again, the statements were also voluntary. Certainly her will was not overborne. It was not coerced. She had the wherewithal to lie about the circumstances of the living circumstances to avoid getting in trouble with a CPS case. So I don't think you can say that these statements were coerced. And then even if they were, given all the evidence in this case, any error was harmless. She admitted throughout her testimony that she used drugs in the house while caring for her two twins. There was drugs everywhere. The home was in disarray. She tries to claim that she was careful not to have the drugs in the one room that the twins supposedly stayed the entire time. I think given the circumstance of the case, even without the statements, you can certainly conclude that she was grossly negligent and she caused the death of her son.
Am I right that the children weren't even supposed to be there?
That's correct, Your Honor.
She didn't have custody of them.
That's correct. The children were supposed to be with her mother. The father had unsupervised visitations. It's not clear whether he could have them overnight or what, but she was not supposed to be there with the children. That's correct. I have nothing else unless there are other questions.
Questions? All right.
Thank you,
Mr.
Your Honor.
Simon, thank you. Okay, very good. All right, appreciate your arguments and your appearance here today. The case is submitted. That brings us to item 16, docket number 3686, 356, People of the State of Michigan versus Richard Michael Faust.
Good morning, Your Honors. Taylor Fellows with the State Appellate Defender Office here on behalf of Mr. Ricky Faust. Today I'll be focusing on issue 1, the ineffective assistance of counsel claim that goes to his conviction, but I'm happy to answer any other questions that this court may have pertaining to his other issues. This case comes down to a simple, uncontested fact, and that is that the complainant identified several people who she claimed were present in the home on the day of the alleged incident, and Ricky's trial counsel failed to investigate a single one. This is about trial counsel's failure to conduct a simple, basic interview. Now, we did have a Ginther hearing in this case, and at the hearing, it was established that trial counsel knew about each of these individuals, including Fred Faust, Brianna Faust, and Luke Schell, and that he did not interview any of them. Trial counsel's failure to investigate, especially in a case that weighed heavily on the credibility of the complainant, lacked any sound strategic justification. And counsel testified to his basis for failing to investigate these individuals. And he claimed that he didn't do it because he asked Ricky for names and numbers of people that Ricky thought would be helpful witnesses. And Ricky only produced one, a TJ Thomas. He also said, trial counsel also said that he doesn't call witnesses who he believes might corroborate the complainant's testimony. And then if the prosecution fails to call them at trial too, he likes to argue to the jury that, what could their testimony have been? It probably would have contradicted the complainant. Both of these justifications are unreasonable. Ricky is a 19-year-old with no criminal history and no special familiarity with the criminal legal system. And he was facing a very serious offense and a mandatory minimum of 25 years. Ricky failing to name any of these individuals as someone that may be helpful does not absolve counsel of his duties to investigate.
How was your client prejudiced, even if we agree that trial counsel should have done more?
Yes, Your Honor. So this case rested, as I've already said, almost.
Didn't he make an admission?
I'm sorry?
Didn't your client make an admission?
You may be referring to the
Grandfather?
the father.
Yeah,
So
the father.
Ben Dever.
Yeah,
So the complainant's father testified at trial for the first
Foster
time
brother.
that Ricky confessed to him that he did engage in sexual contact with his daughter. And Your Honors, I do just want to kind of highlight that the circumstances around this alleged confession are highly unreliable and questionable. And I think that a reasonable juror was questioning it at the time. And had the complainant's testimony been impeached with the information that was gathered following the Ginther hearing or through the Ginther hearing, it would have been under even more scrutiny. You have a man who says that he learned that his daughter was assaulted, and then he spoke to that individual that his daughter accuses, and that person confessed to him. Before he talked to police, before he talked to the prosecution, he then contacts the police and doesn't mention that this man confessed to him. He talks to the prosecution in anticipation of trial, and it doesn't come up. And then at trial, his justification is that he thought it was hearsay. But he's at trial testifying to as much. When hearsay it would certainly be hearsay. If any of time you have a concern about hearsay, it's at
The
trial.
point is that the father had all these conversations with the police and prosecutors,
Yes.
never mentioned any kind of admission, and then it only came out. I mean, to your understanding, the first time that it came out to anybody's knowledge was at trial?
Yes, and that comes up on the record, and trial counsel surprisingly does not object at trial, which is a separate, situation where he's learning for the first time about this confession. And the
What was the
prosecution,
basis of the objection at that?
well, I think at that point, a reasonable attorney would have called for a bench conference to learn whether or not there had been a Brady violation as to why the prosecution didn't disclose a confession from one of their key witnesses.
That's not a Brady violation.
I'm sorry, not a Brady violation, but just information from the prosecution that has not come up.
Prosecutor is not required to produce that. Exculpatory information is required to be produced.
The defense counsel could have cross-examined the father with respect to the fact that we're hearing this for the first time today, right? You've never previously indicated that my client told you this? Just
Yes, Your Honor.
today?
Yes, Your Honor. And that did happen. So at trial, the trial counsel does say, this is the first time that this is coming up. You never told the police, you never told the prosecution, and that comes up. And as I said, the jury does hear this. And so the circumstances surrounding the confession are questionable, but the jury still has the credibility of the complainant, right? To, highlight whether or not that this happened. And so I'm saying that had the jury heard this impeachment evidence to the complainant, coupled with the questioning of Ben Dever as to why he is disclosing this for the first time at trial, that produces reasonable doubt for the jury. So I think that it is clearly prejudicial here that trial counsel failed to investigate. And it's not just that this testimony, it's not just what the witnesses would have testified at trial, but it's also how the trial attorney would have prepared for trial had he had this information. He could have called them, and even if he didn't call them, he could have had information that he could have used to impeach the complainant. And the court, the lower court, the trial court focuses
Were all well, let me back up. Were any of these on the prosecutor's witness list?
Yes, Your Honor. Two were on the witness list. Luke Schell and Brianna Faust were both named. They were all three listed in the police report, and the complainant also named all three at the preliminary examination.
There was plenty of opportunity for defense counsel.
Yes.
To learn, even independent of your client, him asking your client, tell me who I should talk to.
Yes, and Your Honor, trial counsel testified at the Ginther hearing that he was aware of these individuals, right? And again, he only investigated the one person that his client said might offer him an alibi, right? And so the trial court focused here on its main concern with the testimony from the individuals was that there were inconsistencies between the witnesses and there was a lack of specificity. And I would like to just focus a little bit in on Luke Schell, because I think that this really highlights that there are no inconsistencies among the witnesses, and there is quite a bit of specificity between them. But Luke Schell in particular is an interesting witness to focus on here, where he definitively says he was not in the home on the day in question. He said that he and Brianna had not been dating, had not started dating until after she turned 16 and she was 15 on the day in question. And that even though they were friends or perhaps talking before, this is on cross-examination, even if they had been talking before she was 16, he had still never been to the Faust house before she was 16. And he also testified that he had never even watched a movie in Ricky's room. So there's not even a question about a confusion about the date. Luke is a pretty neutral witness here because he's not particularly friends with Ricky. He has no reason to lie about when he started dating Brianna. He's grown at the time of this Ginther hearing, so there's no teenagers not wanting to get in trouble. He's also no longer dating Brianna at the time of the Ginther hearing. And his testimony is also corroborated by Brianna. She also testifies that Luke never watched a movie in Ricky's room. She also testifies that they were not dating at the time of the alleged offense and that he had not been to the house until after she turned 16. Fred Faust, the grandfather here in this case, is where perhaps his memory, and he admits as much at the Ginther, is not as strong. And he says, it could have been that they were dating. We did have a rule that they couldn't date before 16. It's possible. I don't really remember. I would defer to them. And I think that the trial court really relies on that to create these inconsistencies within amongst the witnesses. And I think that that's just an inappropriate reading of the facts here and reading of the testimony. I think the testimony really speaks for itself. They are all pretty clear as to what happened and where they were and what the circumstances were. And each and every one of these witnesses has a bit of information that contradicts key aspects of the complainant's testimony. This was a one-day trial where she says that this event happened on a specific day under very specific circumstances. She was certain of, where she was, what day it was, who was in the room. She's also consistent from the preliminary examination, the police report to trial. And when you have witnesses who can say, I wasn't there, I'd never been there. She and I have never watched a movie in Ricky's room. That is important for the jury to hear. That is important for the jury to know. And when you have a 19-year-old facing a 25-year mandatory minimum, I cannot believe that a trial counsel would fail to investigate the individuals that the complainant said were in the home. This was deficient performance, and there's clear prejudice here, and I'll save my time unless there are other questions.
Any other questions? Not at this time. Thank you. Thank you. Ms. Davis.
May it please the court, Jasmine Davis appearing on behalf of the people. This court should affirm Foss' first-degree criminal sexual conduct conviction and sentence for raping his 12-year-old niece, MD. Counsel was effective despite not investigating Luke, Brianna, Fred, or JD or calling them as defense witnesses. The first thing I want to point out is witness credibility is a matter for the jury. The jury heard MD testify, and they also heard JD testify, and they also heard counsel say, okay, we didn't hear from Luke, we didn't hear from Brianna, and that's why, you know, the prosecution's only putting on half the case. That's a reasonable trial strategy. And first of all, counsel's failures not to investigate these witnesses was not deficient performance.
What is the reasonable strategy behind that?
So the strategy is to show, okay, we know there were people in the home. Prosecution didn't call them. Maybe they had evidence that would have been exculpatory, and the prosecution is hiding it.
Hanging out there, in other words, rather than, okay.
And so, you know,
And that might be a very reasonable strategy. I don't understand the strategy of not even talking with them though, because if defense counsel had learned that Luke, for example, would testify that, no, I'm not allowed to watch a movie in this house because she was too young and I knew the rules that her parents put in place, rather than just having it hanging out there as a maybe, wouldn't it have been more powerful to actually bring them in and say, yeah, no, I wasn't there?
Well, but the bottom line is that none of these witnesses saw or heard or observed the rape. So as to counsel's decision not to even interview or call them prior to trial, they didn't see anything. Whether they were there or not, no one was in the room when Foss locked the door.
But that's almost always the case. And a lot of credibility is attacked through whether the whole story is consistent. And I trial strategy and who you call as a witness, I think we give a lot of leeway. I just don't understand the strategy of just not even talking with them before trial at all. That doesn't seem to me to be reasonable whatsoever.
I would argue.
If that's the case, was there prejudice here?
Well, that's the thing. Even Foss has to show both deficient performance and prejudice. And so if the court's for some reason not convinced that it wasn't reasonable not to even interview them, then there's certainly no prejudice. Everything that came out at the Ginther hearing all went to like collateral matters, whether Fred was there, like MD said, or whether Connie was there or not. None of that goes to the elements of CSC1, which is that a person over 17 had sex with a person under 13. We have a confession from Foss. Benjamin did testify. Foss admitted to sexually assaulting MD, and whether or not that was told to the police by Benjamin, the jury heard the cross-examination, the testimony that came out that he didn't tell the police because he thought it was hearsay, and it comes down to credibility. Apparently, the jury still found the testimony credible because they convicted Foss. That's not a reason to say that counsel, that Foss was prejudiced. Going back to the lack of prejudice, the testimony between the proposed witnesses was inconsistent. When you look at Luke and Brianna both saying that Luke was not present in the room right before the sexual assault, they both have a motive to lie. It was against Fred's rules for Brianna, a 15-year-old, to have her boyfriend over.
Even have a boyfriend at that.
Yeah, to even have a boyfriend. So they have motives not to be truthful as to whether Luke was there. So their credibility on that point is weak. And then you have Fred saying he might have been allowed to be in the home. He wouldn't have been allowed to be upstairs in the room, but he might have snuck into the room. So the testimony is not even strong to refute MD's claim that Luke was in the room right before the rape occurred. Going further toward the lack of prejudice, again, we have Foss' confession that he raped MD. We have MD's testimony. And the bottom line is that none of the proposed testimony would have significantly or meaningfully undermined MD's credibility about the elements of the offense. So even if counsel should have, for some reason, at least called these witnesses, which I say it was reasonable for him not to, knowing that none of them were in the room, it just did not prejudice Foss, that decision under Strickland.
Your understanding was the prosecutor surprised to learn that the defendant had admitted the crime to the father during testimony? I mean, was the prosecutor like, oh, I didn't know about this?
I don't think the prosecutor knew about it. It did come out for the first time at trial. And so, I mean,
Does the transcript make that clear? The prosecutor's like, wait, what?
it
That would have
doesn't,
been nice to know.
it doesn't make it clear, I don't think, but it's something that came out and that's great for the prosecution. But again, like counsel did his job and cross-examined and said this was never in a police report, made it clear to the jury, like, why should you believe this? Benjamin never said this before, and they still convicted Faust. So at the end of the day, Faust hasn't shown that his counsel performed efficiently or that he was prejudiced by these decisions not to call these witnesses. None of their testimony would have refuted the elements of CSC1. It's just simple matters about who was home and who was not home. And you're dealing with a 12-year-old girl who had been raped. She might not have an accurate recollection of exactly who was present and when. That's fair. So even if they had testified all that, the jury still probably would have, or at least there's not a substantial probability that the jury would have acquitted Faust just because of the proposed testimony being admitted at trial. And then, just as to the other issues that are raised, a lot of these issues have already been decided either by this court or our Supreme Court. So I would say under the principle of stare decisis, you have to follow those prior decisions. And I'll just leave it at that since the focus was on the ineffective assistance claim.
Questions,
Thank you.
Ms. Davis? No. Any rebuttal, Ms. Fellows?
I just want to be clear that the standard is not substantial
Right.
probability.
Reasonable.
It's reasonable probability. And to counsel's other point, the complainant's credibility is not a collateral aspect of this. It is a critical element of
What to her point, which I think, is well taken, that a 12-year-old, let's assume that a 12-year-old had been raped. She might not get all of the details right about who was there, who left at, the room at what time or whatever. But, the fact that the violation would be probably front and center on her mind. That seems like a fair position. I mean, how do you respond to that? That, yeah, maybe she was a little fuzzy or wrong on some of the details, but on the main point of what happened, there's reason to believe her. How do you respond?
I say that looking at this one-day trial, Your Honor, where the witnesses are the complainant, her sister, who is 10 at the time and 8 at the time of the offense, who is essentially repeating verbatim what the complainant says, and her father, who has this late confession on the record, that I apologize, I just lost.
Why it's not reasonable for her to be right about
Yes.
the big event
Yes.
and wrong on some of the ancillary details.
Yes, sorry. At this trial, the credibility of MD in large part comes from her consistency across the course of the investigation and everything. So she's consistent to police, she's consistent at the preliminary examination, and this all comes up. You testified to the same facts at the preliminary examination. Is this the police report? And you told the police the same thing at that time. This is bolstering that she for sure knows that this happened and is not making this up. This wasn't a dream. It wasn't a wrong person. It wasn't just a lie made up.
Is it fair to say your point is that her memory about the ancillary events bolsters her credibility?
Absolutely. Your Honor.
About the big event?
Absolutely.
Okay.
When she says there are several people in the house, he kicks someone out of the house in order to perpetrate this offense against her, out of the room, excuse me. And he kicks the JD out of the room in order to have this sexual conduct. That's important for the jury to hear. And when you start chipping away at that, JD would have told an adult if she had been kicked out of the room. Brianna was not there. She does not remember watching a movie that day. Her boyfriend She was not dating anyone at the time. And she doesn't have any memory of this happening. And counsel suggests that the witnesses had incentive to lie. And I just don't see that here. At the time of the Ginther hearing, both Brianna and Luke are both adults. And I understand there may be some desire to not let your parents know all that you got up into. But when you have sworn testimony on the record before the court, I don't understand why two adults would lie about whether or not they were sneaking around in their younger years in the house. Like, years had passed at this point. And Luke, again, as I said, is a pretty neutral witness here, where he is not in the Faust family. He's not related to Ricky. I believe he testifies that he's not friends with Ricky, and he's testifying, I had never been in Ricky's room. And so you have the complainant saying, Luke was there, Brianna was there, my grandfather was there. And each of these witnesses says, no, no, no.
Okay.
That is highly
I
relevant
think
to
we
the
did.
jury.
Anything else?
And I just wanted to go back to the deficient performance prong for a moment. And I just want to say it's not reasonable, as Your Honor was saying, it's not reasonable to say, oh, I wanted to say to the jury that they may have discredited the witness or the complainant. You could have interviewed them and you would know. And if they weren't called by the prosecution, that should pique your interest even more as to why they weren't there. But you should have been prepared going into trial with what they were going to say. And if they refuse to speak with you, then perhaps that is a strategy that you use going into trial. But it doesn't just go to impeaching the witness, the complainant. If the witness was called, you want to know, whether or not there's anything that you could impeach them with. You also want to know a little bit more about the circumstances of the complainant, how she was that day, how she was after the fact. Even if they weren't in the room, it's still unreasonable not to interview them. And unless there are other questions.
Any others?
I don't.
All right.
Thank you.
Your Honor.
Very well argued on both sides. Thank you. The case is submitted. With apologies to the lawyers I know are here for item 17, the court's going to take its recess now. And we will come back and finish our 10 a.m. call and work our way through the 11 a.m.
Session 2.
All right, welcome back. We'll conclude our 10 a.m. case call with item 17, docket number 373754, estate of Kathleen M. Michalski versus Great Lakes Physicians Organization.
Good morning.
Morning.
Mark Ranzaro on behalf of the plaintiff appellate. I don't think I'll need to take up too much of your time, so I'll reserve the bulk of my time if needed.
Sure.
This is another case that involves fallout from the Michigan Supreme Court's July 2024 decision in the Daher case. I have raised two issues based on the circuit court order. The first one involved the dismissal of plaintiff's claim for lost earning capacity damages. My assumption when I read the circuit court's order was that the circuit court read Daher, as eliminating any chance of recovery of lost earning capacity damages. That was my assumption. And if my assumption was correct, the circuit court was completely incorrect with respect to the reading of the Daher case. And I noticed that the Daher opinion is 28 pages long in its published form. But to realize that the circuit court erred, if indeed that was the circuit court's ruling, you only have to read the first sentence of the Daher opinion, because the Daher opinion did not eliminate lost earning capacity future damages as a item of recovery. It only eliminated those damages if they were not to support a survivor. The first sentence of the Daher opinion said the issue in this case is whether the Wrongful Death Act allows recovery of damages for lost future earnings absent a showing that a beneficiary is entitled to those earnings as financial support. And obviously, the whole ruling of the Daher case was that 2922 sub 6 only allowed for the damages that follow the word including, but one of that itemized issue of damages is in fact loss of financial support. So it's awfully clear, and you can find a few other places in the Daher opinion where the court makes it clear that these types of future economic losses are recoverable as long as there is evidence that it goes to financial support. That is not a problem in this case. As you know, Daher involved a 13-year-old boy who was the decedent. He had no wage earning history or economic earnings of any kind, but more importantly, the plaintiff in the Daher case was relying on this court's decision in Denny, and you didn't have to show financial support, and the plaintiff in Daher made no effort to do so. And the end result is the plaintiff could not, under the particular facts of Daher, collect for loss of financial support for the survivors. Obviously, this case is different. Mrs. Michalski had a right to a Social Security benefit, which lapsed when she died, and that Social Security benefit was the only means, well, along with her husband's Social Security benefit, their only means of support. So it's not going to be very difficult for the plaintiff to establish the additional element, which was obviously lacking in the Daher case. Now, what's become interesting in the case is, if I read the defendant's brief to this court, I didn't even have to appeal this particular issue because the defendant is willing to concede, if I have read their brief correctly, they're willing to concede that there is a difference between loss of earning capacity, which the trial judge's order dismisses, and loss of financial support. So if I read the defendant's brief correctly, they read the circuit court's order very differently than I did. And they say, again, if I'm reading it correctly, that financial support is still in play despite the way that the trial court's order is written.
Mr. Granzetto, I'm looking at your questions presented, and the first one has to do with economic damages based on the value of lost household services provided by decedent, okay, and loss of Social Security benefits. So you've included both in the first question, both the services and the financial support. Okay. All right.
So maybe this didn't need to be appealed, but there is ambiguity in the way the judge's order was entered. I think the defendant is now willing to concede that we can proceed with loss of financial support. Not going to be very difficult to prove in this particular case. And I think that basically resolves the first issue. And the second issue, believe it or not, is even easier because the second issue involves household services. That one clearly the judge dismissed. And we have an intervening published decision of this court in the DeMott case, which is obviously binding on this court under 7.215. And I have somewhat given a fancier version or fancier reason as to why household services are recoverable. I don't think I need to bother you with that at the present time in light of 7.215, because you've got to follow DeMott, and DeMott says that household services post Daher are in fact recoverable.
Any questions for Mr. Granzato? All right, you have plenty of time for rebuttal.
Your Honor, Sandra Lake on behalf of Dr. Chevali. I'm going to start off this hearing by throwing a bit of a wrench out there. And both of us missed this, I have to admit. I did as well. But when I was looking at the order that granted leave, it says that it was limited to the issue of recovery for the value of services that would have been performed by the decedent.
Okay, thank you.
So I don't.
It wasn't, so my disconnect here is not with the way Mr. Granzato presented the issues in this appeal, but rather in the order granting leave that came from this court, which appears to have limited the issues to the household services. Is
That's
that
correct.
your argument?
Yeah, so I don't know if the court wants me to get into the future earning capacity issue or just limit
I
my
would.
comments. You would? Okay, very good, Your Honor. Thank you. The only motion that we brought in the trial court as to future earning capacity was to dismiss any claim of the broad claim of future earning capacity, which that claim is, and as projected by the plaintiff's economist, a forward-looking claim of the, theoretical.
I'm gonna interrupt you right there, just so I can kind of give you my understanding of this. What you can't do is recover for the earning capacity of the individual decedent. This person was making $200,000 a year, so I get $200,000 a year as the survivor for the reasonable life expectancy of that individual. No, that's not recoverable. But what Mr. Granzato argues, I think, is recoverable is the amount of that. If we take that $200,000, some lesser amount went, if you can demonstrate, factually prove that a portion of that income supported the survivor, that's recoverable. He says that survives Daher.
That's great. And Daher says that at page 22, you can seek actual
You guys are
pecuniary
just citing
loss.
page, chapter and verse here.
I,
First page,
impressive.
chapter 20, or page
It's
22.
only a 28-page.
Huh.
Wow.
but my point is, I never even made that argument in the trial court. In fact, we had a discussion on the record that I wasn't making that argument. What I said to the judge is, I said, down the road, we're going to have an argument about how we define that and what the standard of proof
So
is.
that would, when this-
But the judge never decided this issue.
Okay, so assuming it goes back, we granted leave on the services issue. If we say, if Mr. Granzato prevails in this appeal, then everything's fair game when it goes back, right? Because I think you're conceding that the pecuniary piece of it.
The loss of financial services, yes, they can claim that. What I'm saying is they can't claim the bigger claim of total future earnings of the
Right.
It would
decedent.
only be a portion of those
Correct.
if they can be shown to have supported the survivor.
Correct. And that's allowed under the statute. I don't dispute it. That allows loss of financial support. Now as to the household or services issues, obviously DeMott is binding, it applies. Just a few points I want to make. I'm asking alternatively that this court either hold this case in abeyance pending an outcome in DeMott, which is pending in the Supreme Court.
We might get a decision a year from now.
I do understand that. And so,
Usually July appears to be the big month.
yeah.
Off during August.
Alternatively, I'm asking this court to issue a decision under the on the conflicts rule, holding that DeMott is wrongly decided. And there's 2 points I want to make as to why that is. The first is Daher very clearly says we're limited to those damages expressly stated in the Wrongful Death Act. Nowhere does it state household services. You literally have to be writing it into the statute to say it includes it. But because I'm asking for a conflicts ruling, my second point is I wanted to give you my rationale as to how I reached that. And I think there's a very important parallel between the rationale and the reasoning applied in Daher that also applies to household services. So again, getting back to Daher, we had the forward-looking big chunk of damages, right? Everything someone could potentially earn in the future. But they said, no, you can't get that, but we recognize that some subset of that damage might fall under financial support. And so they said, because that's a subset of those damages, the legislation made a choice to choose the subset rather than the bigger picture damages. And it's my same argument as to household services. Household services are looking for damages, trying to put a value, a theoretical value on what someone's services into the future are. But you could have a subset loss of financial support based on household services. Let's say, for example, that I have an adult daughter and I give her money every week to pay for someone to come clean her house. That would be an example of potentially loss of financial support in the form of household services.
So let me see if I understand what you're saying is, let's just pick one piece of household services, cleaning the house. Are you conceding that at least a portion of that would be enjoyed, would benefit the survivor, and that the survivor would have to then replace that somehow, but it should be a portion, it should only be a subset, not the full, because presumably the decedent would also benefit from a clean house?
So that's not exactly what I'm arguing. So I'm glad you asked me that question. What I'm saying is that when we look, loss of financial support is looking backward. And what the Supreme Court said, it's actual pecuniary loss. So if we're looking backward and the plaintiff can establish that prior to the decedent's death, they were providing financial support in the form of lost household services.
You want to change the facts in that way. I didn't follow your analogy, frankly, involving the daughter. And it doesn't seem to me this is our case. You'd have to look back to see whether the decedent in this case was providing services to her husband. I mean, that'd be question one. If so, then what was the value? I mean, it's pretty simple, isn't it? I don't know why you want to throw in this financial, well, if I'm paying someone to do it.
Because that is my argument, that there has to be a showing that someone was actually financially providing support. Because historically, well, and I'll tell you, in our case law is very lacking in this area. This is why I said in the trial court, we're going to have a whole nother issue coming up on what this means.
To settle it in the first instance, probably.
Because it's going to be an interesting issue.
Now, Demond involved in a child, an infant, didn't it?
Yeah.
Oh, I can't remember now.
Yeah.
I believe so.
So they were looking.
No, that was
It's
Daher. I
different.
think we're thinking of Daher, actually.
Daher definitely
A minor.
did, for sure.
Yeah.
But I believe DeMott does as well, because I'm thinking of the
DeMott
leave
does, 'cause I'm
granted
looking
order.
at it,
Yeah, I think it
So
does.
it's looking in the future. This child didn't provide anything in the past. Yet they were.
Well, we're dealing with an adult in this case, right?
I know.
Right.
I know that, but you're saying you can't look in the future, you can only look in the past.
That's correct, because again, because the Supreme Court or the legislature did not include that broader category of damages in the exclusive
So you're
list.
telling us why DeMott was wrongly decided?
Correct,
Okay.
correct. That's all I have, Your Honors, unless you have any other
Any
questions.
other question?
No.
Thank you.
Mr. Granzato, hopefully you can clear all this up for us.
First of all, the idea of holding on to the case, there's no question, but DeMott is not going to come out until a year from July 31st, I assume. And on the question of whether you can declare a conflict panel, you cannot. And the reason for that is MCR 7.215 J3B, which says that you can't declare a conflict panel if the Supreme Court has granted leave in the underlying disputed case. And the Supreme Court has, in fact, granted leave in the DeMott case. I'm quite familiar with the briefing that's been done since I finished the brief for the plaintiff about 2 or 3 weeks ago. So I have even more sophisticated arguments, if you were actually interested, on the second issue, and as to why household services is completely consistent with Daher. The analysis that was employed by the 3-judge panel in DeMott was purely historical, my analysis differs. And it differs because the reason the Court of Appeals in that the DeMott panel was correct in saying that across history, since the beginning of the first Death Act, household services, particularly between spouses, were recoverable is because those household services under the old wording of the Death Act were pecuniary benefits. And interestingly enough, if you read Daher carefully, the Daher court says the pecuniary benefits that were in the pre-1939 version of the Death Act are absolutely equivalent to the loss of financial support found in the present act, subsection 6. So Daher is completely supportive. Indeed, you perhaps know that the major case that was before the Supreme Court was the Baker versus Slack case. The defendants were arguing that it has never been overruled. A 1948 case of the Michigan Supreme Court had never been overruled, and it was still good law. And that, in essence, with respect to loss of income, they had to, in fact, provide financial support. Well, what's very interesting, if you look at Baker versus Slack, is there's a direct reference to In re Olney, and it specifically says in Baker versus Slack that a husband can collect household services from a deceased wife under the present version of the Wrongful Death Act. So the fact is that there are a lot of reasons why the decision in DeMott is entirely consistent with what the Supreme Court ruled in the Daher case. You don't have to worry about it. And now that I've briefed it, I think let you in on a secret. We are going to win on the issue that is before the Supreme Court, the one issue that matters for this case. But Judge Reardon, you are correct. The DeMott case involves a newborn.
It was an infant up to the age of 18, and I'm wondering what services my kids would give me. I mean, at present, it's
That'd be a large recovery.
Well,
Like an anti-services.
Yeah, someone took the garbage out this morning. I was very pleased with that.
and I mean, maybe you don't need to hear this, but what's really different about household services from loss of income is, Judge Gadoli, you're absolutely correct. It's a subset. It's a subset. You lost earning capacity. You can't get it all. You only get a subset. What support? But it's different for household services. You get it all. Why? Because the proof is this, in my case, Mrs. Michalski did this for her husband in terms of household services. Okay, and she would have done that through her life capacity. So you would get it all. There's no reduction, really, if you present these correctly. That's the one difference. Now, if I can just briefly on the first issue, Ms. Lake is correct. I had noticed the order was granted only on the one thing. I mean, I would ask just to clarify, because I don't want any confusion about this judge's order, because the judge's order says it's dismissed, loss of earning capacity. Now, the defendant has now conceded that that doesn't impact the loss of financial support, and I accept, and I assume they're going to be consistent with that. I don't know what to tell you, but my suggestion is grant leave to say, oh, the defendant has conceded that it doesn't affect a loss of financial support, because I don't want any ambiguity going forward, but that's the problem with that first issue.
Glad you raised that. We'll have to noodle through that as we
Any
produce an opinion for you both. All right. Thank you very much. Interesting case. Appreciate your arguments. They were enlightening. And the case is submitted. Okay, that brings us to our 11 a.m. case call. And I will just get right to it by calling item 18, docket number 379438. Bridget Lee, and I don't know how to pronounce this, Bofsel versus, say that again?
Faisal.
Faisal. Wow. Okay. Hard O versus Sarah Lynn Faisal. And Attorney Curtis will be appearing via Zoom.
It is still,
Okay,
it is
very
still
good.
morning, I believe.
3
1
minutes.
minute, 1 minute to go.
Well, good
All
more
right.
afternoon, Your Honors. Jordan Ayler Smith on behalf of the appellant in this matter. We're here today on a threshold issue. My client had filed a motion to change legal custody, and we are asking this court to reverse the trial court's decision to deny my client's motion to change legal custody on the threshold. If Your Honors will indulge me a little bit, I'm gonna do something a little different than I normally do, which is talk about lots of case law today. In our briefing, we rely largely on Daly versus Clowenhamer. And the reason for that is that I see it as kind of this court's first clear statement on when sole legal custody is appropriate when we're talking about the threshold burden. But this isn't the last time that this court made comment on that in a published opinion. I also cited to the Plachta case, which Judge Reardon, you were on that panel as well, which in my mind, I don't think it necessarily expanded Daly, but I think it explained it a little bit more. Because in that case, we had parties who disagreed about just about every possible thing regarding their two children. And while they were able to resolve some of those disagreements after a party had already filed a motion and there was a motion hearing scheduled, they still had to do the whole legal process to get there. I see that as very similar to the parties in this case, where the practice has been an issue comes up, let's say with the child's orthodontic treatments, and the parties disagree. One of the parties files a motion. The motion is proceeding forward, and at some point along the way, we get agreement. Sometimes it's minutes before the hearing happens, sometimes it's a couple days before the hearing happens, but the parties have essentially been parenting through motion litigation for the last 6 or so years.
So just to be clear, you want us on this record to reverse the trial court with regard to legal custody and actually order legal custody be ordered for your client?
No, Your Honor, that
You
is
just want it to go back for basically a do-over
correct.
or updated.
What I'm asking for is for this court to open the door for us. I'm not trying
That's
to say.
different than I thought. Okay, thank you.
Yes, as I was reading through my briefs in preparation for this, Your Honor, I also kind of got that line, and I apologize for that sort of angle to my arguments. That's not what we're arguing. We are simply asking for this court to open the door for us by reversing the trial court's order denying the motion. We completely understand that this is 100% the trial court's decision. It needs to go forward for evidentiary hearing so that the trial court can hear evidence on these issues and then make appropriate findings under the best interest factors and determine whether sole legal is appropriate. It is our position that sole legal is appropriate, but we're not asking the court to order that today.
Thank you.
And I think that's what the case law that I've been talking about is consistent with as well, is that, you know, the door can be opened because the parties have kind of these protracted disagreements. And I think there is plenty of evidence in this record that these parties have those types of disagreements. And again, it's parenting through litigation, which, as the trial attorney in this case mentioned, you know, this is the case where a motion is filed every time the child has to go to the doctor. It's just not.
It seems like rough circumstances.
You know, Your Honor, it's not sustainable, I think, is the problem. And as the child gets older, these issues are just going to continue to come up. They're going to continue.
The child's 10 years old now, and so they have 8 more years of this.
Correct. And it's just not sustainable. It's not tenable. And I do think that the trial court's decision here was incorrect and that this court should reverse it. And Your Honors have a very good handle on this case. So I am happy to sit down unless Your Honors have any questions for me.
No. Okay, thank you. You'll have
Thank
time
you.
for rebuttal. All right, Ms. Curtis, I believe it is. We can't hear you. Are you muted? Still can't hear you.
Um, oh, can you hear me now?
Yes.
Okay, thank you. Your Honors, this is a case. Are you getting the feedback?
No.
Okay, I'll ignore it. This is a case that should be affirmed because appellant was unable to support that the trial court's decision was not unable to support her claim that the trial court's decision was against the great weight of the evidence. She raised only 2 medical issues and 1 school issues. The 2 medical issues were resolved, both were resolved by agreement, one with the trial court's help. The school change issue, the judge did find reason to send that issue to an evidentiary hearing, but eventually ruled against appellant on that, and this court denied leave on that. So the issues that appellant has brought up are not different than the factual issues that were in the 2022 custody order. In other words, the issues that this court already addressed in the 2020 published decision of Faisal. Because there's no real changes, there's no evidence. Appellant has provided no evidence of the claimed escalation. She only provides broad generalizations, like my client is continuing her historical thwarting of appellant's presence in the child's life. That's just very general, and besides which is untrue.
Ms. Curtis,
Yes.
as I read the record, the trial judge essentially made 2 rulings on this issue. The first one was oral and indicated that with regard to legal custody, nothing had occurred since the previous custody order that, quote, demonstrates that there's been a material change of circumstances, close quote, that should change legal custody. And then almost a year later, 8 months later or so, a written order was entered that said plaintiff has failed to demonstrate there's been a change of circumstances or that proper cause exists. During the first oral argument, or during the first oral ruling, no reference to proper cause at all. The second time, we just have this statement that there's no proper cause shown. Doesn't the trial court have to do a little bit more on explaining why there was not proper cause here? I mean, in terms of appellate review, I literally have I have no idea why proper cause was rejected by the trial court. Maybe appropriately. We don't know.
Well, the general rule for proper cause is that it has to relate to one of the best interest factors and cause a significant effect. And I was just getting to the point in my argument stating that more importantly than what the prior factual incidents were is the fact that appellant has not shown evidence that she was able to bring any evidence of a significant deleterious effect on the child, which in different wording has to be found under both changed circumstances and proper cause.
You might be right, but don't we need a factual finding by the trial court explaining, maybe that lack of evidence?
I believe, and I'm sorry, I don't have the judge's opinion in front of me, but the judge did say changed circumstances, but also said no significant effect on the child. So that probably would cover it, although I do understand what you're saying.
Counsel, what about the fact 8 months passed between the oral ruling and the written order?
That, Your Honor, was appellant's choice. I think she did not get that order entered until she already had filed 2 applications for leave, and then she got the order and filed this claim of appeal and asked to have them all consolidated. But they were not consolidated, and the 2 other appeals were leave was denied for lack of merit. And I think the most obvious rebuttal to the claims about significant effect on the child under either prong is that by all accounts, these 2 parties have raised a delightful young girl who is on the path to a college education. Yes, there have been a few kerfuffles on both sides. The one I could think of, and I mentioned in my brief, is appellant unilaterally changing the dentist, which the judge ruled against, and there was no appeal on that. So they have had their problems, just like they did prior to the this court's published opinion, and yet this court found, despite their communication problems, there are ways to work around that, and the court ordered that. And the way they did in this case, and the way that we see a wonderful child in this case, is like in Barhas, which Judge Reardon, that was an unpublished opinion of yours that is in my brief. The court said something that's applicable here. Despite their problems, these parties both ultimately prioritize this child. And that's what's come through in this case. And the trial court was in the best position to determine that on the facts. And it's clear that this court carefully considered all of the issues, especially in that while not finding a threshold on these medical issues, the court did find a threshold on the school change issue, but ultimately decided against it. But the court is clearly making thoughtful decision in this case. And the court deemed these issues relatively minor and resolvable. So my conclusion is, given the lack of strong evidence or almost any evidence for appellant's claims, the trial court properly found that there was no reason to disrupt this child's custodial environment that has been working so well. The decision was not against the great weight of the evidence, and we ask that you affirm this decision.
Any additional questions for Ms. Curtis?
No.
Okay.
Nope.
Ms. Ayler-Smith, any rebuttal?
Just very briefly, Your Honor. I'm going to start with Sister Counsel's assertion about the entry of the order here. So the hearing was held in May. The trial court, as Sister Counsel mentioned, then went forward on an evidentiary hearing on the school issue between May and I want to say September. And at the end of that hearing, trial counsel realized that we still didn't have an order on the legal custody change. Trial counsel filed a motion in either late September or early October for entry of the legal custody order, and the trial court still didn't enter it until January. So there was no game playing on our part in terms of getting this order entered. It was one of those things where they had other things that were happening. When trial counsel realized we didn't have an order, she immediately went forward and tried to get it entered, and then the trial court just did not enter it until the trial court finally did in January. In terms of the standard, Sister Counsel had mentioned something along the lines of it has to affect the welfare of the child. The Vodvarka standard is that it has the capacity to, it could have a significant effect on the well-being of the child. A showing that it absolutely for sure has a significant impact on the welfare of the child is not required. It just has to show that it could have a significant impact on the welfare of the child. And I will say that the case law that we cite does have kind of, more of these disagreements, but in those cases, both the Daly case and the Plachta case involved children that were either medically fragile or had some other sort of special need. One of the children in Plachta was a very, very good baseball player. I think he was nationally ranked or something like that. So they had lots of disagreements about his extracurriculars. I think the point here is that while the parties may not have as many opportunities to disagree, every time they have to make a decision, they are disagreeing to the point that litigation has to be involved. And that is not an efficient way to parent a child. I don't have any children, but I can assume it's not an efficient way to parent a child. And the published opinion in this case that Sister Council mentioned from 2020, that was when the child was significantly younger. As Judge Reardon pointed out, she's 10 years old now. I believe she was 2 or 3 at the time the appeal was filed in the original appeal, and I think she was maybe 4 by the time that the opinion was actually issued. The method that the parties were using just doesn't work anymore. It doesn't work for what decisions the parties have to make these days. And really the only method that they've found that gets them anywhere close to a decision for this child is parenting by litigation. And it's not an efficient way to parent a child.
Pretty expensive way.
And it very expensive, Your Honor. You are 100% correct. That's all I had for Your Honors. So unless you had any further questions for me, I would ask that this case be submitted.
Okay, thank you very much. We
Thank you.
appreciate your arguments. Thank you, Ms. Curtis. And the case
Thank
is
you.
submitted. All right, that brings us to item 19, docket number 378600, In re Draheim Kellogg Gates Miners.
Good morning, Your Honors. Ryan Deal, counsel for the respondent mother and appellee in this matter. I know that the court's had an opportunity to review the brief. I've, briefed it thoroughly. I am really merely here to answer any questions that the panel may have regarding this matter.
Questions for Mr. Deal?
I don't have any.
No, I don't.
Thank you
think
very
so.
much.
Thank you very much for
Thank you.
appearing. We appreciate it, and we'll try to get a decision quickly.
See you on the next case.
Yes.
Right. Item 20, docket number 378119, In re A. Reeves III minor.
Yes, Your Honors, once again, for the record, Ryan Deal, appearing on behalf of the respondent appellant mother. And once again, I've fully briefed this matter. I wanted to make my appearance here to see if the panel had any questions for me related to this case.
Questions for Mr. Deal? We don't have any.
With that, I ask that the matter be submitted.
Thank you very much.
Thank you very much.
Submitted. Thank you. Appreciate your appearance here today. Okay, we will work through our last 3 items. Item 21, docket number 378104, In re Guardianship of LAV will be submitted on the briefs. Item 22, docket number 374682, Bay Area Transportation Authority versus Grand Traverse County. We have attorneys who we said could appear for questions. You're here. Do my colleagues have any questions for counsel on this matter? Surprised you that neither side preserved oral argument on this case, but you didn't. I don't either. Thank you for coming down, I'm guessing, in the case of some perhaps. Case is submitted. Thank you. Item 23, docket number 379249, In re N. Sanderson minor will be submitted on the briefs. And with that, we are adjourned.